Because I practice in San Diego, California, basically minutes away from the border, I'm always fascinated by all the cases that deal with international border, checkpoints, and all the ports of entries. Now, this particular case comes out of the 10th Circuit, and it deals with reasonable suspicion to search electronic devices, including your laptops, cell phones, and so on, at the international border. I recently represented a client who was searched and questioned at the border on things that were unrelated to her entry. Now, it's very similar to what happens in this 10th Circuit case of United States versus Williams Jr. November 2015, Mr. Williams, who's a United States citizen, takes an international flight from Europe to Denver, Colorado. When he lands at the airport, he's met by the Customs and Border Protection agent who sends him to the secondary because there's an alert on Mr. Williams' name. During the initial interview and questioning, the Border Patrol agents ask Mr. Williams to open up and power his cell phone and laptop and provide them with a password so they can take a look at the information contained on those devices. Mr. Williams refuses to provide that password. So the Border Patrol agent takes the laptop to a different room where he uses a program called Encase, which allows the agent to take the hard drive, copy the information to a different computer. In that way, he's able to bypass the requirement of the password and simply look at the information. With his cursory search of only 3 minutes, he's able to see some incriminating information, so he goes ahead and tries to get a warrant to look at all of the devices. Mr. Williams argues that that 3-minute search in itself was illegal and unconstitutional. The 10th Circuit refuses to make a ruling on whether reasonable suspicion is required for searches of the electronic devices done at the border. Instead, they simply say that they don't need to rule on that issue because in this particular case, the Border Patrol agent had reasonable suspicion to open up and search that device. And here's why. First, Mr. Williams had border-related criminal history, meaning that Mr. Williams has been previously deported from Germany and has illegally entered Germany and other countries that he was banned from. Second, Mr. Williams did not list Germany as one of the countries that he actually visited on this last trip on his declaration. And instead, he told the agents that because of his advanced age of 39 years old, he couldn't remember all the details of his trip. Third, Mr. Williams was returning with a one-way ticket from Paris to Denver, Colorado, after visiting Belgium, France, and Morocco, 3 countries that were intimately linked to that Paris terrorist attack of 2015. Moreover, he didn't list Germany, but he was arrested in Germany during this trip for brandishing a weapon. And finally, Mr. Williams appeared to distance himself from these electronic devices because when the agent told him that the agent might have to keep these devices to later mail him to Mr. Williams, Mr. Williams decided to provide a different address than the one that he listed on his declaration earlier and the one that appeared on his identifications. The court says that under totality of circumstances, these 5 reasons were enough reasonable suspicion for the Border Patrol agent to search and seize the device at the border. Now, Mr. Williams makes one additional argument, and this is the one that I tried making in my case earlier this year. Mr. Williams suggests that the Border Patrol agent's job is to stop importation of illegal drugs and other substances and enforce laws that deal with the border and not go on a fishing expedition to find other crimes unrelated to this particular entry into the United States. Now, at least the 10th Circuit disagrees, and they say that the law enforcement never has to close their eyes to other crimes that might be happening right before them. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And of course, if you'd like to read this case in full, please click the link below in the information.